The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Wednesday, March 9th, 2016 are currently trading with gold at $1,252.65 an ounce, silver $15.29 an ounce, Texas crude $36.50 a barrel, and Bitcoin is currently sitting at about 411 U.S. currency. Today in history, the year 1961, the first animal safely returned from space after completing one full orbit around the Earth in Sputnik 9. A doggy named Chernushka, or Blackie, returned from the heavens. Today in history. In recent news, Tayrod Pugh, a U.S. Air Force veteran, was found guilty today of attempting to join the Islamic State. After a week-long trial at a Brooklyn federal court, a jury found Tayrod guilty of attempting to provide material support to ISIS and guilty of obstruction for destroying 4 e-storage drives after his detention in Turkey. Pugh is set to be sentenced in September. Pugh's defense lawyer is arguing that all he did was express repugnant views about the Islamic State on Facebook and watch dozens of the group's recruitment videos, and that he was only traveling to Turkey to find work, not to become a jihadist. However, prosecutors are presenting a letter he apparently drafted to his Egyptian wife, which was found on his laptop, in which he vowed to fight for Islam. When detained in Istanbul, he apparently had a black face mask, a map depicting Islamic State's strongholds in Syria, and a chart of the border crossings between Turkey and Syria. Pugh served as an avionics specialist in the Air Force from 1986 to 1990, and later worked as an Army contractor in Iraq from 2009 to 2010. Toyota recently showed off a new device that could dramatically assist the visually impaired to better navigate their surroundings. Called Project Blade, an informational device to bridge the gap between a cane or a guide dog. Toyota has been testing various prototypes of the wearable device with individuals from the visually impaired community for the past 3 years, and though the details of the project were released this week, no official timeline has been set for the release. The automaker plans incorporating mapping, object identification, and facial mapping technologies into Blade in the future. Doug Moore, manager of Partner Robotics at Toyota, told ABC that Toyota is thinking about quality of life for individuals and how to impact society. The Lone Star Lowdown is currently looking to fill some ad space. If you have a product or service you'd like to advertise with us, feel free to give me a call at 210-363-2257. This is Rick Rohde with your Lowdown for March 9th, 2016.
Received my remedy today. Came in a box just like they say. I accepted it for value right away. If not sooner, not later. We are originators, and the pathway seems to get straighter every day. And I can take anything that belongs to me and put it to good use. Whatever's good for the gander is gonna work for the goose. Some architects, I know some engineers. They see me every day.
Okay, Randy Kelton, Root of Law Radio, here with Ron Avery, and we're going to go to Mark in Texas. Mark, did we hurt your feelings when we trumped you for Mark in Texas?
Oh, are back to me?
I know how you Wisconsin guys are. Okay. Okay, now. Ron, Mark he has really been working these people over, and he understands how to take a bigger company and take them to the wall. He's really worked these guys over. What's your opinion on what you think Ron should do in this case? Do you have a recommendation?
Well, from a social media standpoint?
Yes, we were talking about that on the air.
Okay. All right.
I was talking about the politics side.
Okay.
The hard copy media are losing incredible ground to the internet, and it looks like the writing's on the wall that eventually they'll just pretty well be swallowed by the internet. So they're going to be sensitive to the internet.
All right.
From a social media standpoint, what kinds of influences do you think you may be able to bring?
Well, the first thing is he need to have the case, as much of the case as he can put online. Now, notably, the American Bar Association Standard Code and the Wisconsin rules, both of them have things saying you, as an attorney, you can't reach out to the media and discuss things in the media. However, I have not found on a state level in Wisconsin anything that bars the self-represented from doing exactly that. Now,
wait a minute. Ron, you're not self-represented, are you?
Yeah, I'm operating pro se, and I have already everything online, every word. The record is, the hearing is not online at the moment. I'm trying to get that. But every filed document is online. It's already on there now, and I have videos of kind of an explanation of the case and all that kind of. Yeah, I put all that online. It's at postwtc.com, and then it has a link to Avery Sue's the Houston Chronicle, and it's all everything in there.
Okay, that's Post POST
WTC like World Trade Center. Post World it's WTC.com.
Okay, we promote shameless self-promotion.
Yeah, wonderful. Then a call out to all the listeners that they should entertain going to that website, picking something, and posting that to wherever they read. So if you can get it started on Reddit or someone who has followers on Twitter or Facebook, keeping in mind that in Twitter is around 20% of the U.S. population. Facebook is used by over 75% of the U.S. population. And if it can find someone where it can catch fire, you could get some nice publicity and people creating the public issue. Let's see. Beyond that, pictures, the people like pictures and messaging more than just straight up words, although I'm not sure how you're going to create a picture to be worth 1,000 words to cover a defamation type thing. That's outside of my creative ability. Let's see. If you can find, and the more you can phrase and put a frame around the issue of it being a large corporation, being beating up on a little guy, that's good. Another possibility is, if you want to explore, is that our whole legal system is based on the Magna Carta, and the Magna Carta was a document that was calling for it was an open demand for a revolution. So perhaps tying the fact that the whole legal system's basis is a document for revolution, that you may be able to get some play elsewhere.
Yeah, I think, quite frankly, I'll be honest with you, operating by yourself with very little means, I don't even have an attorney. I don't have any time to do anything more than simply handle the case itself. And, of course, when it comes to trial time, the closer we get to trial is when I'll have to hire a lawyer. You can't handle a case like this in a trial as big as it is by yourself. Even if I was an attorney, I couldn't handle it by myself. I would get somebody else to work with me. And so even though that sounds good, and if I had means and I was a corporation myself, that had employees and things, I could maybe do some of that. But this is all of that kind of stuff is out of my range. I will not even attempt that. But I can put all of this other stuff. I can put all the material online, and people can go to it and see what it's about. And I have had the alternative media has been helpful. Mark Anderson, that's really who that was, and he doesn't mind me using his name, I'm sure. He's already written a couple articles on it in American Free Press, and they're available. I have links to that on my website. And so it's not like it doesn't get any coverage at all. It's getting pretty good coverage anyway, at least in alternative media. But it could be bigger. It could be made bigger. But even as I've consulted with a lawyer on these cases, and he said, don't even have anybody in the courtroom. I said, during this hearing and all that stuff, go in there by yourself. I mean, let those big shots come in, and you just go in there by yourself and argue it. And I wasn't going to run off some of my friends that were here. I'm certainly not going to run off the guys from the alternative media. And so I went, no, I want these guys around, and I want to go to lunch with them afterwards and, talk about it. So I did have some friends in the courtroom, but they weren't, flamboyant and sticking out or anything. So that was a good thing. And I think I actually did pretty good at that. I at least got the judge to not make a ruling immediately. And so it's, I don't know really where everything's going, but I just think it's worthy legally to pursue. I don't think they ought to be doing this. And as I've said before, I didn't really have an alternative. Once I found out I was basically called a terrorist and I needed to be waterboarded in Gitmo, and that I was a secessionist when I've been speaking against secession for probably 15 years. And I'm probably the only guy I know that ever speaks of dissolution and has developed a full theory of dissolution and shown it and written about it. I am totally offended. It's like anybody that knows me at all knows that I am an advocate of the observation of dissolution. And so it's going against my whole professional look at history.
Well, from my experience in dealing with courts pro se, I kind of agree with not having a bunch of people in the gallery who may have agendas different than yours. And I tell people when they write pleadings, the only way the judge should be able to tell that this was not written by a lawyer is there's no bar card number under your signature. So there's none of this man on the land, this stock patriot lingo that people tend to use in documents.
Yeah, I don't do any of that. I do it straight up just like any other attorney would do it.
And that's likely to get you a lot farther, especially when you're a non-attorney and you come in there with a similar, or if not higher level of expertise.
And the other thing my attorney told me to do as a pro se, he said, don't try to out-lawyer the lawyers. You don't want to act like you're a smart ass. And all of that makes sense. This is just common sense. Why would a non-lawyer go in there and try to look like a lawyer?
You have to remember the judge is a human being.
Yeah, and I wouldn't like an architect that is not an architect trying to be an architect and acting like one all over everything. That's kind of like, well, you're being an idiot. So I just try to represent myself straightforward, straight as I can, and try to make sense out of it. Anybody that would try to make sense out of something. And use the law like anybody, use the case law and use the statute. And I can complain about some of it, and I've done that. But I didn't ask the judge to find something that wasn't there and all that kind of stuff. Good,
and that'll get you a lot farther.
I think so. Yeah.
Doing this show, I get frustrated often with people that have unreasonable expectations.
Yes, that's true.
That go into the court without a suit and tie. Well, I shouldn't have to dress up. Well, probably in a perfect world, you wouldn't have to dress up. That's However, right. If this were a perfect world, there's a good chance you and I wouldn't be in it. I know I wouldn't.
Well, I'll tell you the way I looked at that. I look at the court, no matter what, as it really is, should be, or at least should be, a reflection of the people of Texas. The purpose of the court is for the protection of the people of Texas. I happen to be a people of the Texas. And I looked at the judge not as an individual person. I looked at him as the people of Texas, and to look at my material. And so I approached him as he was sitting there as the people of Texas, and I talked to him, and I called him Your Honor because people of Texas, you're their honor. And so I think I was correct. I think that's what this is. And whether it's effective or not, or whether it's corrupt or not, it's what it's supposed to be. So I treat it as what it's supposed to be.
Yeah, and that's the best thing we can have. It's good, knowledgeable, well-read, pro se litigants. It'll gain traction for all of us. Hang on, we're about to go to break. Randy Kelton, Real Law Radio. A call-in number, 512-646-1984. We'll be right back.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Well, don't let nothing get to you. Only the Father can deliver you. So don't let bad mind people hurt you. Until Satan get behind you. Know what I mean? My friend. And all of your children. Come, those things that hurt me free. Tell him your problem then. Call on his name once again. Miracle, you know he worked the in. Trust in God, my friend. Tell him your problem then. Call on his name once again. Miracle, you know he worked the in. He am the king, man, he is everything. He's everything to me, that's what I call him. Not at me, and me pray to him. Because he's the only one could answer him. Me no business what wicked man saying. Mankind, you know, is this leading. Me cannot trust in God, me friend. Tell him your problem then. Call on his name once again. Miracle, you know, he work the in. Trust in God, me friend. Tell him your problem then. Call on his name once again. Miracle, you know he work the in. No business what you call him Buddha. You call him an Allah or you call him Jehovah. Call on his name and you call Rasta. Pray to him and he'll deliver. Miracle, he work.
Okay, we are back. Randy Kelton, Rule of Law Radio, and Deb is back, and she is on the board. And it turns out this noise that we've been having is the caller bridge. So if you were on a call and you had some disruption, that was Deb blanking out these different tracks to find out where we would get this noise. So apparently it's still there. So we may have, we can't take calls for now. So I apologize for that, especially for you folks that have been on for quite a while. This is an unusual problem. I've never encountered this before in all the time we've done it. And I do apologize to Ron for this problem. I would very much like to have you back on.
Well, great. We can do that. Sure.
Let's do this again. So, and when we do this again.
Okay, sounds fun.
Since you're very well known and you have a big following, let's try to develop a presentation of the case that will make a good archive where we can pull pieces out of it so that we can put it in other places. Social media is becoming very powerful.
Yes, it is.
And,
sure. Yeah.
And if we can get other people, especially people in the movement.
Yes.
You know, I'm labeled as a enemy of the state by the American Poverty Law Center.
Yeah. Yes.
And so this is something that's important to me, and we have a lot of people out there who are fighting the system or potentially considering fighting the system. They're going to find this interesting and a considerable threat.
Yeah.
You know, we get a lot of people calling in that are really, really frustrated with the press.
Right. And they should be. If they're paying attention at all, they should be really upset with this stuff.
Yeah, and you know, we want to, when I get up in the morning and I turn on the news and I hear these people talking, I want to believe the words that they're using actually have some truth in them. And most everybody does. And mostly our community, the legal reform community, has come to understand that for the most part, that all of that is smoke and mirrors. You know, I've had experience with news reports concerning situations that I had personal knowledge of. And not one of the stories got it right. Most of them were not anywhere near close. And this mostly happened when I was much younger, before I come to understand the way the world really works. And I was mortified that I knew about this story, and all of the reporter had to do is come and gather the facts and regurgitate the facts. Well, they came and gathered the facts and they just regurgitated nonsense. And it wasn't important one way or another. They just got everything wrong.
Yeah.
And that was so frustrating. So now I see stories that I don't know anything about, and I'm looking at it thinking, is any of this stuff true, or do they just make up stuff and stick it on the air? And
fabricated. They just fabricate it.
Yeah, and not fabricated from some specific purpose, just for stupid reason, because they're too lazy to line out the details. But in your case...
that's called negligence. You know, some of that's called negligence. But the other stuff, some of this involved in this case is not negligence, but malice. You know, when you start fabricating something you know is wrong, in order to slam some people, that moves into malice, and that's defamation for sure. And so there's lots of facets to a case like this, and lots of issues to be determined. And
yes, your case is a good example of how to do this right.
I hope I can keep it on track of doing it right. And like I say, if I can survive this motion, where it keeps the defendants in the court and in trial, and if I can eventually get it, to where we're doing discovery and things like that, and leading up to a trial, some of my journalist friends tell me, Ron, they're not going to go to trial with this. There's never going to be a trial of this. If you can stay in court and proceed towards a trial, they will probably settle, because they don't want to lose a case like this and then lose on appeal and all that. They don't want to do that.
Oh, absolutely not. We got a case down last year, a Jasanowski case. It was out of Minnesota. And when I looked at the ruling, I thought, what were you thinking, Wells Fargo? How on earth did you ever let this get to the Supreme? Mm-hmm. The Supreme absolutely dropped the sky on them.
Yeah.
And it was the stupidest case.
Yeah. Why pursue something you almost know you're going to lose?
Yes.
And
what were you guys thinking?
My attorney even looked at my stuff, and like I say, he's not signed on, and I do pay him, for his time, but he's an older guy. He's semi-retired. He said, I can't do trial. He's a good trial attorney, but he's not in good enough health right now to do a trial. But he's been helping me looking at it, and he says, Ron, where's their defense? He's asking me straight out, and I have to tell him, well, I don't see it. And he says, well, I don't see it either. So eventually they're going to have to come up with something. And I can't see that it's, go to trial and lose and not be able to win on appeal. I mean, talk about a big old something that wouldn't look good. And they'd be out money all at the same time. That doesn't make sense at all.
There's a question I didn't ask you that I should have. At the end of the day, for you, what would be an equitable outcome? What would be the minimal equitable outcome for you?
It actually depends on how much they drag me through the street to get there. If they came up with something right now, pretty soon, probably wouldn't take much. But if they're gonna drag me out for 5 years, I'm old myself. I'm no spring chicken, and they're going to drag me along for a long time. It's just going to get more expensive for them, because I'm going to want more and more. Every day I want more.
Okay, I'm going to touch on something that I should have talked about to start with, about these kinds of fights and the experience I've had fighting them myself and dealing with people who have fought them. And it's about not getting caught up in the fight. And I'll speak to that when I come back on the other side. Randy Kelton, Root of Law Radio, here with our very special guest, Mr. Ron Avery. We'll be right back.
Fly me to the moon and let me play among the stars. Oh, yeah. Out-of-this-world vacations may soon become a reality, and space entrepreneurs are taking reservations. I'm Dr. Catherine Albrecht, and I'll tell you more in just a moment.
Your search engine is watching you, recording all your searches and creating a massive database of your personal information. That's creepy, but it doesn't have to be that way. Startpage.com is the world's most private search engine. Startpage doesn't store your IP address, make a record of your searches, or use tracking cookies, and they're third-party certified. If you don't like Big Brother spying on you, start over with Startpage. Great search results and total privacy. Startpage.com, the world's most private search engine.
Would you like to spend your next vacation in space? That day may be coming. 8 private spaceship airports or spaceports have already been built, and test flights are underway. Companies like Space Adventures and Virgin Galactic are pre-selling seats for space cruises designed for the regular public. Forget the $40 million price tag the Russians have been asking for rides to the space station. Suborbital cruises start at just $102,000. Take out a second mortgage, and you could be on your way. Promoters expect that space travel will eventually become routine, and prices should drop even further. Me? I love adventure, and I love a bargain. I'll send you a postcard from space. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Live Free Speech Radio, LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Real Law Radio, and apologize for the extended break. We're working through some technical difficulties. For the time being, the call bridge is down. Deborah's working on it and rebooting service and stuff, so we won't be able to take any calls for the time being, but we may get it back up before the show is over. So if you're on the call bridge, you might as well interrupt the call because we won't be able to take you. If we can get it back up, I will let you know, and we'll pick back up with it. But Ron had to go, but there was, when we went out, I was addressing an issue I should have addressed at the beginning, and that is, what is an equitable outcome? I don't know what an equitable outcome for Ron would be, but when you're fighting a case like this, he needs to know what it would be. And if anybody gets into a case, from the perspective of a legal reform person and someone who rises up against the inequity, it tends to come with the perception that we fight them to the bloody end. And that's not always how we win. When you have someone like Hearst Industries that, for the most part, has limitless funds to throw at this, they can wear you down and wear you out. But they don't really want to. They got other stuff they'd rather be doing than fighting a pro se in court. And for the most part, they don't like to fight pro ses, because pro ses are a pain in the neck, especially if you get a pro se that knows what he's doing. You get a pro se that knows what he's doing, and he can bring issues that the lawyers do not want to have to deal with. Lawyers like to deal with what they always deal with. They like to handle issues they're very accustomed to handling. They don't like having to research out new issues, because one of the worst things a lawyer can do is misquote case law or miss something that he should have found. And I've talked to a number of lawyers about legal research. And every time they research out a new issue, they're always terrified when they go to court. They're terrified that they missed something. And when they get in court, they're certain that the other lawyer, whatever it is, will not have missed it. And he's going to bring in the issue, and you're not going to be able to argue it. And then your client is going to sue you for malpractice. The lawyers are terrified. So even though they got the money to wear you down, they don't want to. They want this thing to go away. So when you get into a lawsuit of any kind, the very first thing you should do is decide for you what would be an equitable outcome. That way you know when you can gauge when you're winning and when you're losing. I had a friend in Pennsylvania who was helping people with foreclosure issues. With IRS issues. And one of the people she was working with, they sent him to a neighbor who had some IRS liens, and they wanted to get rid of them. And she looked him over and said, "You want to get rid of these?" And they said, "Yes, we do." She ripped them up and threw them in the trash. And they were flabbergasted. And she said, "Look, these liens expired 2 years ago, and the IRS didn't renew them." These people were furious, and they wrote a scathing letter to the IRS. So what did the IRS do? They reinstated the liens. What were they thinking? They had been in this fight so long that it became about the fight and not about an outcome. They won the case and didn't even know it. So, when you get into a legal battle of any kind, what you need to do is sit down first and decide for you what would be a equitable outcome. That way you know when you're winning. And once you reach that out, and in order to reach the equitable outcome, and I say equitable because it's always about the money. Yeah, I understand it probably shouldn't be. But in the real world that you and I live in, it's always about the money. And if you're going to be able to gauge when you're winning and when you're losing, write down a number. And once you have that number down, the first thing you should do is go to the other side and play, let's make a deal. Well, they're probably not going to want to make a deal. And you hope they don't want to make a deal. And you ask them for a deal that's a whole lot better than you're willing to settle for. At least give the semblance of attempting to negotiate an equitable outcome. So that if the other side reaches the point where they want out of this litigation, you have an opportunity to get out of it. And if you've written down what for you is an equitable outcome, then you'll know, when you have reached the point you want to be at. So always, first thing you should do is have an exit strategy. Something that'll let you know when you've actually won this case. I hope that makes sense. And good. Got my clock back. I was a little distracted by clock. They rebooted the system. I guess my clock went out, but I got it back. So first thing is equitable outcome. Decide what would be a win for you. The minimum win. What would be the least that you could, in good conscience, live with? Okay, once you got that, then ask for more than that and start the negotiation process. Negotiation process does a couple of things for you. It lets you put leverage on the other side, put pressure on the other side. Because you can go to the court and ask the court, if the other side won't mediate with you, ask the court to order mediation. In most circumstances, they won't or even can't. But you're just a dumb pro se. Heck, you don't know that. And you want to make a deal. So what it tells the court is you're not some pro se fomenting litigation and giving the judge a pain in the neck when he'd rather be out playing golf. You want to make a deal to make this go away. And it's the other side that's keeping this in front of the court, not the pro se litigant. So we're back to the thing that everything is political. And perception is everything. If you give the court the perception that you're reasonably trying to make an equitable settlement, then the judge is going to be irritated at the one who's forcing him to read all these pleadings. Like in Ron's case, he's got to read this whole stack of 100 and something pages. He would rather be out playing golf. So if it's the other side forcing him to do this, he is not going to be happy with that other side. Randy Kelton, Rule of Law Radio. I think our call bridges may be coming back up, but I'll let you know when we come back on the other side. If they are, then we can call back in. So hang on. Deborah's online, and Deborah knows everything. She'll get them fixed. We'll be right back. Okay, we are back. Randy Kelton, Rule of Law Radio. And while we're waiting for the bridges to come back up, I do want to talk about this case a little bit more. I really have a lot of respect for Ron for taking this issue on. This is a large endeavor. Here we have a pro se taking on one of the biggest companies in the country. These guys got very deep pockets. So they can just keep dragging this out and dragging this out. I just talked to someone recently who was just having to stop and walk away from their case because it just consumed their life. And they just didn't have any more money to fight it. And this is what companies like this count on, is that they can wear you down. And they'll keep pushing things at you until you run out of time or money. So in looking at this from the perspective of the pro se, the courts hate pro ses, but they don't hate pro ses because pro ses write stupid pleadings. They like that. Makes it easy to screw them around. They hate pro ses because every once in a while they come across a pro se from hell. The pro se who's listened to this show and got some ideas about how to go after them, how to take the fight back to them. Lawyers are terrified of judges. But pro ses, they don't need to be terrified of judges. Lawyers can get their bar card pulled on a whim. A judge can put a lawyer out of business just on caprice. But we don't have a bar card for the judge to take. A lawyer will never challenge a judge directly because he loses his bar card. We don't have bar cards. We can challenge the judge directly. I've asked the judge to get down off the bench because I didn't like the way he talked to me. I asked the judge, this was in a traffic case. I told the judge it was my understanding that you're here to determine the facts in accordance with the rules of evidence and apply the law as it comes to you in the facts in the case. But you've indicated that you have some other agenda. With your angry voice and your loud speech, am I to understand that you brought something else in the courtroom with you? And if you did, you need to get down off that bench and have yourself replaced by the fair and competent judge that I have a right to in the first instance. And the judge sitting there not believing what he's hearing. But also not knowing how to respond to it. What's he going to do, hold me in contempt? And we have a contempt hearing over what I just said. Every time I speak in court, I'm always thinking, how will what I'm about to say play in front of a grand jury of my peers? If you go into court always thinking that, then it will govern your speech in a way that the other side will recognize. Not only will it make it extremely difficult for them to lodge an accusation against you, they will also recognize that by your speech and by the control you have in what you say and what you do, that you're setting them up. It's always been the most powerful thing that I have found, is to create the perception that you're setting them up, because only pro ses can set them up. Lawyers can't do that. Pro ses can come in and set them up all they want to, and there's nothing they can do about it. So we do have power in the courtroom if we just learn how to wield it. The last 2 or 3 cases I had thrown out, and we have Scott from Texas who was calling in because he has crowing rights. He just got one thrown out. And it was because he took them on. And he took them on professionally. He took them on using their rules against them, the way they use their rules. He was more professional than they were. So there is a lot that we can do to gain political influence. And this is all about politics. It's not about the right of things or the rule of law. But in order to get there, the first thing you have to do is have a talisman in the form of a goal, an equitable outcome. Once you got that, that's going to protect you from a whole lot, because now you know where you're going. If you don't know where you're going, odds are you wind up somewhere else. Once you know where you're going, then you need to understand that as a pro se, you're the most powerful person in the building. They're all public servants. You are the master. So before you get to the adjudication of the case, you come into the courtroom in your capacity as the master of the servants. The servants are there to perform their duty in accordance with law. If they fail to do so, you have a remedy you can kick their behinds, and they have no recourse. Primarily because you have to expect the judge to rule against you out of hand at every turn. You just have to expect that. Okay, maybe the judge won't. Maybe he'll rule in your favor, but if he does that, that's a gift. And the other side will appeal anyway. So it doesn't make a whole lot of difference what the judge does in court, other than helps you to get your facts and law on the record. That's all you want to do in court. Get your facts and law on the record. If you have facts and law that's substantial enough, there's a good chance the judge may actually rule in your favor. But if you're a pro se, there's a lot of pressure on the judge not to rule in your favor. Because he's a lawyer. And he works with all these other lawyers. And he knows all these lawyers. They deal with one another all the time. To come in and rule against one of his professional colleagues to the benefit of a pro se, somebody who comes into court and denies these lawyers in their livelihood, they think you're stealing from them. This is their job. This is what they do. And you come in and do it yourself. You deny one of us lawyers our wages. They really feel that way about us. So even if the judge doesn't want to be, he's going to be prejudiced against you. Even if he's otherwise an honest and reasonable judge, this prejudice is going to be there. You have to understand it, accept it, and deal with it. And like I told Ron on the break, but just before he left, it's him and I were engineers. He's an architect. I'm an electrical engineer. And we don't have philosophies. Engineers don't have philosophies. We just connect the dots. That's all we do. If you're going to be a good pro se litigant, you have to just connect the dots. Leave all your philosophies at home. My tech manual are statutes and case law. This is the tech manual. I don't have opinions about them. These are the parameters I have to deal with. Okay, I may think something's really unjust. Okay, so what? I leave that out of the courtroom. Leave that at home. Don't bring it in the courtroom and get me all upset and angry and frustrated, because then I'll start acting in a way they call agitated. And then the court will disregard anything I say or do. So I leave all that at home. I'm a mechanic. I connect the dots. I lay in these facts and show how this law or this case law relates to these facts such that the court should rule in this way. That's all I'm there for. If I forget that, I'm going to lose badly, and I'm going to lose justifiably. You'll lose your case as much for procedure as anything else, and often more so. So your only purpose, the procedures you follow, are the rules of court, and you proceeding to court for the purpose of getting the facts on the record and getting the law on the record with the case. Once you set the record, your job is done. If you happen to win in doing this, because if you do it right, you do it without emotional involvement, and you present the facts in a professional manner, the judge will tend to forget that you're a pro se. I have no doubt that because of the way Rod Avery presents himself in court, that the judge will very soon forget that he's pro se. He's in the court, he's got the facts, he's got the law, and he presents them professionally. He becomes like one of these other lawyers, and the judge loses some of that intentional or unintentional bias. And he may actually rule in his favor. But if he does, that's just a gift. Don't expect it. Don't depend on it, because you'll always be disappointed. Once you can get to the Court of Appeals, that's where you can win your case. And looking at Ron's case, he's pretty confident that if this goes to the Court of Appeals, he will absolutely win. And this is how we should handle our cases. Hang on. About to go to break. Randy Kelton, Rule of Law Radio. At the moment, our phone bridges are still down. We're still trying to get them up. As soon as we get them up, I'll let you know, and we'll start taking your calls. And we'll be right back.
Story for everyone to hear about how we're not gonna give in to the fear. Yeah. expenses when it comes to taking his place.
Take a thief in the night, I saw the fire enter. Chase all the parasite from around ya. Thief, liar, and even murderer. Chase them out the house because them cannot enter. Pure in heart and clean hands only. Only them could enter in God's house, you see.
Okay, we are back. Randy Kelton, Boulevard Radio. And we're still having trouble with phone bridges. We're a little late coming in because we thought we had them working, but it looks like the problem is turning out to be faulty equipment. So it appears as though we're going to have to replace some equipment on the phone bridge, and this is problematic because we were already low on funds, so it's really beginning to stress us out. Part of the reason we're having this problem is because we've been running equipment that needed to be replaced quite a while ago. And I have to give Deborah credit. She's keeping this thing going on absolutely a shoestring. Other radio stations, GSN Network, they have a massive budget. And not to disparage GSN, but we produce a better stream because Deborah is so meticulous with how she produces this show. But she does it for a fraction of what it costs other people. And it's because she just spends all of her time doing it. And we spend every extra dime we can get on the network. So if you appreciate what we're doing and you find value in what we're doing, we would appreciate some help to keep this thing on the air. Because frankly, right now we're struggling. Anyway, enough of that. We've got another hour, so I'm going to go through some things that I like to go through these kind of on a somewhat regular basis, some of the basics of what people need to know, need to understand in order to be able to find remedy. And in doing this for a long time and studying it, and I study it from an engineer's perspective, I don't have these philosophies. I'm looking at, over the years, what have we seen that works well? I had one caller, Scott from Texas. And Scott's been listening for quite a while. And he got some couple of tickets. He listens to Eddie's show, and he didn't renew his license, and he got 2 or 3 tickets because of that. But he decided to fight him, and he decided to fight him because it was just the right thing to do. And once he started to fight them, then the court started to do what they normally do, is they just, whatever you bring, they don't care. They're just there to make money. So then he and I got to talking, and I got into paying attention to what was going on from the perspective of the master and servant. He was the master, they were the servants. Yet he engaged the servants to enforce the law, even if it was enforced against him, because we ask our public officials to protect us, even from our own excesses or distraction. But when we empower those public officials to act, we give them very finely defined restrictions. If they exceed those restrictions, then it is our duty as the master to take them to task. And that is exactly what Scott did. And he filed what any prosecutor would consider a frivolous complaint. He filed criminal charges against a municipal court judge for yelling at him in a hearing. Now, if you yelled at the judge, you'd go to jail for contempt of court. But then you're in the courtroom as the master of the servants, and he's one of the servants. Just who does he think he is, yelling at a litigant? That indicates that the official has an emotional stake in the outcome, and that disqualifies the official. If the official has some emotional stake, he needs to leave that at home. If he wants to yell at somebody, go home and yell at your wife, and then see if you can go to sleep tonight without her dumping ice water on you or something. But when you stand before your master, I expect my judges to conduct themselves with a certain amount of dignity, respect, and civility. and make sure all of their actions are within the limits of their authority. Well, this judge yelled at him to prevent him from making the right to travel argument. So he went to the grand jury and filed criminal charges against the judge of witness tampering. How's that work for you, Judge? And after that, he's noticed police pull in behind him and a couple of times because his plate's expired. They follow him a little ways. Then they turn off and go get somebody else. This is what happens when they run into a pro se who knows what he's doing and is willing to do it. So he just went into court today, and he had bragging rights today because he went into court. And the court called him up first. Generally, they call us pro ses up last. But they called him up for it first and told him that I'm just going to hand you my hat on this one. You're dismissed. They had apparently found out what he had done in other courts, and they wanted nothing to do with him. Now, from a purely purist perspective, the judge had a duty to prosecute the case. But for our purposes here, we won't raise that issue. The point is when you take them on, and when you take them on using their own law against them, they don't know how to deal with you. And in the end, they want not to deal with you. They want to get your case out of their court as fast as they can. And the way we will fix the system is by getting more people in a position to give the judge reason to want their case out of his court. Then they start following law and doing things right so that they don't wind up with more criminal charges filed against them. And here's a good place to go to the process. We tend to run public officials through the process. And the process is you ask a public official to do what he's required to do, and he's going to refuse. What he's going to do instead is do what he's been trained to do. Do what he's always done. Act in accordance with policy. And the complaints I like to file the most are complaints alleging a public official of following policy. And I have one right now that I'm working through the system. I'm going to go through this. It's a little bit complex, and that's what makes it even better. In last year, the legislature passed legislation, Texas Government Code 411, and it went to public integrity units. You know, Ron Earl is the one that got public integrity units put in place. And then Tarrant County has one. All the big counties have a public integrity unit. And they investigate into crimes by public officials. Well, when I first looked at that, I considered a public integrity unit section of the district attorney's office to be in criminal violation of law. And the reason it's in criminal violation of law is Article 2.03, which says essentially when a prosecuting attorney is made known in any manner that a public official has violated a law relating to his office, he shall reduce the complaint with information submitted to the grand jury. This is the very first statute in the Code of Criminal Procedure under duties of officers that gives a public official a specific directive to do a certain thing. And it directs a prosecutor, when he gets a complaint against a public official, to give it to the grand jury and to submit a complaint to some magistrate. Well, that would eliminate any discretion on the part of the prosecuting attorney. So what in the heck is he doing investigating crimes against public officials when he's supposed to give that to the grand jury? And if the grand jury wants to investigate into it, well, they actually have to, because under 20.09, it shall be the duty of the grand jury to investigate into all crimes subject to indictment that come to their knowledge by way of any member of the grand jury, by way of the prosecuting attorney, or any credible person. So by reading those in conjunction conjunction or in paramateria one with the other. It appears as though it was the intent of the legislature that when there is a complaint against a public official, the prosecuting attorney, who may well work with that public official, not be put into a position to where he has to investigate into somebody he works with. Inherent conflict of interest. So they took that authority away from the prosecutor and gave it to the grand jury. So it was my contention that this public integrity unit was illegal, and it appears the legislature has agreed, and they transferred that authority to the Texas Rangers. And when we get back, I'll talk about the shenanigans the higher-ups in the Texas Rangers have pulled to take the teeth out of that legislation. Randy Kelton, Rule of Law Radio. We'll be right back.
This is the Logos Radio Network.
Oh, come on. If I can't get everything I want, yeah, to get arranged, yeah. If I can't get everything I need, maybe get arranged, yeah.
Okay, we are back. Randy Kelton, Rule of Law Radio. And it looks like the bridge is going to be down for the rest of the day, so we won't be able to take any calls today. And I'm going to continue. I'm really not speaking so much to a specific process as to a way of thinking about what we're doing. It does lend itself to some specific processes, but once you shift the way you hold your mind when you walk into a courtroom, then the processes will essentially dictate themselves. If you walk into the courtroom from the perspective that you are the master of the servants. Now, as the master, you do not come into the courtroom expecting any special privilege. It's part of your directive that there be no special privilege. And this goes to this notion of seeking justice from the court. We don't go to the court to get justice. We go to the court to get adjudication of law. The court is to determine the facts in accordance with the rules of evidence and apply the laws that comes to him to the facts of the case, not to juxtapose the court's concept of justice on the legislation that is designed to promote justice. If we want justice, we go to the legislature for justice. We go to them and say, the law as it's written is not promoting justice, change the law. And we change the law and then watch the effect of the law. If the effect of the law promotes justice, wonderful. But the last thing we want is for some judge to come in there and decide that what he thinks is just is what should be done. We have one of those in Fort Worth, Judge McBride. He's a federal judge. 88, 89 years old, been on the bench way too long. I think he's lost his perspective. He's had people coming to him asking for his favor in his rulings too long, and he forgot that he is a servant of the people and thinks he is the master of them. Well, he's not. We don't need a judge to decide what he thinks is just and apply his concept of justice to cases. That's what happened in the common law. And the common law had some serious problems. Because it was common law, the judge could rule on what he thought was just. What he thought was just depended on who paid him the most. Humans are flawed. It's just the way it is. They're flawed. And everybody can be bought, and in a common law system, whoever's got the money is going to get justice. So our founders fixed that. They created a system where the law is designed to promote justice, and the judge simply administers the law. When they fail to administer the law, you as the master have a duty to exercise the remedies that are contained in the law. You can't expect lawyers to do it because the judges put them out of business. You, the individual, have to do it. And it's not so difficult as it sounds. You will find that every public official in the process will resist doing their job. And when I first started it, that was one of the more difficult things to deal with, is I knew what the law said. I knew precisely what the public official was supposed to do, but the official just refused to do it. And they did so with relative impunity because they were certain that they would receive no repercussions, because all of these folks are public officials, and this particular individual is protecting one of his buddies. He could expect his buddy to protect him in return. So that thing we call the good old boy system. So the problem was, how do we get around that? And the solution is we start turning the good old boys against one another. When the first one refuses to perform his duty in order to protect the second one, then the first one gets charged himself. Now, he has to answer for trying to protect his buddy. So you go to a justice of the peace and you file a criminal complaint. And the justice tells you, well, you really need to give that to the police department. So what do? You take your complaint to the police department? Not exactly. You take a complaint against the justice of the peace to the police department, accusing the justice of the peace of failing to hold an examining trial when noticed that a crime had been committed. Now you get the chief of police looking at it from a whole different perspective. So when you give it to the chief of police, even though he may look at it from a whole different perspective, he's going to do what he's been trained to do. He's going to do what he's been doing his whole professional career. He's going to refuse to present it to some magistrate. Article 2.13 Code of Criminal Procedure directs him in what he's to do. But he's not going to do this because that's not what they do. I had a judge that I respect greatly, Judge Autry. When I went to him with the Criminal Procedure Code, the Texas Code of Criminal Procedure, this is the procedure when a magistrate has it made known to him that a crime's been committed. These are the things you're supposed to do. And I walked through the steps that were required to be there that weren't there. And Mark looked at me and he said, Mr. Kelton, are you telling me that everybody in the state of Texas is wrong and you're right? That the way we've been doing things in the 20 years I've been in law enforcement is wrong and you're right? Don't ask me, Mark. I didn't write the code. I just read it. Show me where I'm wrong. Have I missed something? Is there another set of code out there I haven't seen? And Mark was acting in good faith. He was probably as honest an individual as I've ever come across. As fair and honest an individual, and as courageous. He didn't do this because he was afraid not to do things the way that always been done. He did this because he believed this is the way it should be done, because that's the way everybody that's been doing it. All these people who know more than them's been doing it this way. And then I get this know-nothing pro se come along and tell me that everybody's doing it wrong, and he just didn't believe to trust him. Mark had to have this notion that he's missing something. There's something out there that justifies what we're doing, and he missed it. Well, I asked him for it, and he didn't know what it was, and I've never found it. So it's important, I guess, to understand that for the most part, you're dealing with people who are not acting maliciously. They're acting in what they believe to be the best of faith. And that's why I always say I never want a public official indicted. Because I'm going to accuse them of following policy. I don't want them indicted for following policy. But I do want them to have to answer for following policy. Now, they can claim good faith reliance on competent authority and throw their boss under the bus if they want to, and that's what I want them to do. But they can take the heat themselves. But what this will do by taking them on their own practices will influence them to change the practices. And what I did just here recently in the county I live in is I filed criminal charges, first-degree felony aggravated assault against the district judge with the Texas Ranger. And I did that in order to get protocols changed, and I'll explain that when we come back on the other side. Randy Kelton, Real Law Radio.
Do you have a chocolate monster inside? You know, the one that forces you to eat a chocolate bar even though it's not on your diet? I'm Dr. Catherine Albrecht, and I'll be back in a moment with a tip to tame temptation that really works.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
There's nothing quite like melt-in-your-mouth chocolate, but it can sure sabotage a healthy diet. When I get a hankering, I just recall the U.S. Food and Drug Administration guidelines for adulteration and filth in chocolate. You might think the agency would forbid filth and contamination, but they don't. They just set limits. For example, the FDA allows an average of 59 insect fragments and 1 rat hair in 100 grams of chocolate. To put that in perspective, 100 grams is about the weight of a 3.5-ounce sampler box with 8 chocolate candies. Yuck. Just think wings, legs, and hair the next time you're dieting. It works like a charm. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
I see two. I see tools of ingenuity, used against the workers of iniquity. Tools of massive capability, available for all eternity. Yeah. They come from natural divinity, with steadfast roots and authenticity. I see tools to regain dignity, to rebuild the credibility. And I say, truth in nature must be justice, I believe. Truth in nature must be justice. And though it's a daunting task, at least I got the decency to ask them all to just take off the silly mask. And in the light of day we all will pass, and the tools of ingenuity, used against the workers of iniquity. Tools of ingenuity, used against the workers of iniquity. Tools of ingenuity, used against the workers of iniquity. Tools of massive capability.
Okay, we are back. Randy Kelton, Rule of Law Radio. And Deborah the Magician has found a temporary workaround. So we've got the bridges temporarily back up until we can replace some equipment that seems to have failed. So if you have a question or comment, give us a call. Scott, I'd like to see you call back in. You have crowing rights today. So the bridges are up, and I'm going to go back to what I was talking about. Where I was going is we just follow the thunder. In a case in the county I live in, I went to the district court in order to challenge the grand jury pool when the court was impaneling a grand jury. And the court impaneled the grand jury without giving me opportunity to challenge the pool. So after the hearing, I directed the judge to reconvene the hearing, bring the grand jury pool back in, disband the grand jury they had selected, and give me opportunity to challenge the pool. And he didn't want to do that. And in the process, he threatened to have me arrested. And Bayless was just all too happy and ran over and one of them put his hand on my arm. So I went to the local Texas Ranger and filed a complaint against the district judge for first-degree felony aggravated assault. 2202B2A if someone commits simple assault while prominently, which is a Class C misdemeanor, while prominently displaying a deadly weapon, it's a second-degree felony. Unless they are a public official acting under the color or pretense of an official capacity, in which case it's felony the first degree. So I charged Judge John Fostel, our local district judge, with first-degree felony aggravated assault for assaulting me with the armed bailiff. I gave that to the Texas Rangers. Now, 4 411, Texas Government Code 411, created a division within the Texas Rangers to investigate crimes against public officials. Now, historically, the Texas Rangers could not investigate a criminal complaint against a public official without the written express permission of the director of the Department of Public Safety. So the legislature required that the Texas Ranger produce a set of protocols for the enforcement of Section 411. Well, they produced those protocols, and what those protocols called for was the ranger going to the district attorney and asking permission from the district attorney to enforce this particular law. Now, that sounded like a bunch of high-level officials not liking the law that the legislature passed, so they set up a set of protocols to circumvent them. It was the intention that the prosecuting attorney not be able to investigate these crimes. So the higher-ups in the Department of Public Safety fixed it so that the prosecuting attorney still had discretion concerning the investigation of these crimes. So I instructed the Texas Ranger that I would be filing this complaint with him, and he said, well, he couldn't do anything with it. And I assured him, I don't care what you do with it. If you give it to the grand jury, I'll be happy. If you don't give it to the grand jury, I'll charge you with shielding from prosecution with the grand jury myself. Well, I'm not going to act on them unless the prosecutor tells me I can. Well, I know the prosecutor, and I consider him a personal friend. And I told him what I had done. And he assured me that if the ranger contacted him, that he would recuse himself. He wouldn't touch it. And I said, perfect. So now if they appoint an attorney pro tem for this purpose, and the attorney pro tem directs the ranger not to pursue investigation of the complaint, then I will accuse the attorney pro tem of conspiring with the ranger to obstruct justice. I don't care what they do. I'm going to follow code, and I'm going to expect them to follow code. And in the process, I'm just following the thunder. I ask a public official to do what the law requires him to do. He either does it or I sting him good. Okay, call bridge is filling up. We got Mark in Texas, and Mark has some crowing rights. Scott in Texas, and Scott has some crowing rights. We'll go quickly. We've only got a couple segments. Scott, you there?
Can you hear me?
I can hear you.
Okay, good. Yeah, crowing rights. Well, number one, talking about the Houston Chronicle, when on that video, I had a reporter from the Houston Chronicle attach me to the Southern Poverty Law Center, post the ad on the internet, and then call me to ask me if I could get his approval, and I never gave him approval. I could sue him straight up. So that's more fodder for your buddy there. We should talk. Now, as far as bragging rights here on the last ticket, I got a ticket on one of my cars for my tags and stuff, and I went and submitted my motions and all that, and the prosecutor, I've been in front of the prosecutor 3 times so far. Every time I go in front of the court here, I win. So I woke up and I told old Brad, I said, hey, Brad, it's good to see you, because I've got a good attitude going towards it. I know I'm right. I'm in the right. I'm using the very law that I'm beating them over the head with, because they're going with policy, and I'm going in with state law that trumps everything that they're doing. And so, boom, I know I'm correct. And then so I talked to the prosecutor like, hey, he's my best friend, right? And so I shook his hand, and he looks at me, and he says, well, Mr. Russo, I'm going to go ahead and have to dismiss this case here. It's just a fight that I'm not prepared to do right now. It's not because of the motions that you submitted. I just want you to know that. And we know dang good and well it was because of the motions, because he had specifically stated, I know you say that you're not engaged in commerce and you're not an operator, and if you want to run around without your tags on your car, I understand. We just may see you back up in here one day. By this time, I'm patting the city attorney on his shoulder, telling him I understand and thank you very much. Have a good day. I'm in and out in 5 minutes when normally I'm dead last. They want to get me out of there so fast they can't stand it. And I'm laughing all the way to the car, and then I get outside and I call you.
This is how it works when you do it right. When you never lose your cool, you never get angry, and you never run off the cliff at the end of this show, end of a segment. This is Randy Kelton, Rule of Law Radio. We'll be right back. Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Scott in Texas. I hate to cut you short because you got crowing rights, but we do need to move on. We've only got one segment, and we got two more callers. So, Scott came in. He followed the rules. He followed their rules, and when they broke their rules, he stung them good. You filed it wasn't this judge that you filed the criminal charges with the grand jury against, was it?
No. This judge, I was getting ready to set him up to file charges on all these guys, and the prosecutor, the city attorney stood down. To his credit, I give him credit for standing down and not wanting to proceed to antagonize me any further, because I was going to bring charges against everybody that stood in my way for violating the law. Now, let me just touch on one other thing, because I did go ahead and indict the cop that smashed in my window Wednesday. Now, I went down to the Dallas County Grand Jury and turned in the criminal indictment. Now, this is funny because the bailiff of the grand jury, he had never seen this happen in the 30 years that he had worked there. He had never had a person come in there and hand him a criminal complaint. And the guy was confused, didn't know what to do, had to go see about finding his boss, couldn't find his boss, and come back. And he was like, I don't know what to do. And I said, sir, it is my understanding. You are the bailiff of the grand jury. He said, yes, I am. Well, it is my understanding, according to the law, that I give you this criminal complaint, and you give this criminal complaint to the foreman of the grand jury, and the foreman of the grand jury will present it to the grand jury, and they will decide how to proceed. Now, are you refusing to take my criminal complaint? He hauled around for about 10 minutes, but he finally took it and wanted to make sure he made a point that he was not standing in my way, and he was handing it to the head prosecutor that just happened to be there. And I said, thank you, sir. Have a good day. And before he asked that, he was trying to get all goofy with me. He goes, what's this criminal complaint about? I said, it's a criminal complaint against a public official. And he backed up and said, oh. And that's when he took my complaint, and we departed.
Wonderful. This is how we take our system back. One public official at a time. And this is the police officer. You charged him with breaking out your window, and this is the one where you had a video of him that got 1.8 million hits on YouTube.
That's correct. And I put aggravated assault on him, Texas Penal Code 22.02.
This is how we take our system back. Now, regardless of what happens with that, they're going to call this officer and say, what is going on? Why is this guy trying to get me to get you indicted for first-degree felony aggravated assault? And this is going to scare the bejesus out of this guy. He's going to see the likelihood of him going to prison for a long time for breaking out your window. This one incident may stop police officers from breaking out windows in Dallas. It may be all over Texas, because these other policemen are not going to want to risk indictment. Sure, they're pretty certain they won't get indicted. But who wants to play Russian roulette? I went into my prosecuting attorney one day, and he's sitting there with his head in his hand. I said, what's the matter, Greg? He said, those darn grand jurors, you never know what they're going to do. And I thought, there is a God. This is the district attorney who feels as though he never knows what a grand jury will do. if ever there was an ideal deterrent to misbehavior by public officials, that's it. All this nonsense about any prosecutor worth his salt can get a ham sandwich indicted, maybe. But how about keeping the ham sandwich from getting indicted? Try that one on, guys. So this is how we'll get our system back. We can get more people doing this. And Scott is beginning to have the problem that I warn everybody about. It's getting to be way too much fun. Isn't that right, Scott?
Yes, sir. I am eating this up. Now I have gotten, thanks to you, I'll give you all the credit, but I'm telling you, now you start to see the system for what it is, and you start to be able to, you get the ability to start setting them up. You're like playing chess. You're 4 or 5 moves ahead of these people. You're waiting for them to screw up because it's like, oh, yeah, got you on this one, got you on this one, got you on this one, and then let's just keep playing because they're just sinking themselves in the hole further and further because you're in the right and they're just in the wrong, going wronger and wronger. That's just how it is. Oh, and one other thing I got to tell you, I talked to Michael Rivero on What Really Happened Radio, and he wants to have you on his show. It's a syndicated show, and he's looking forward to you already should have an email from him because I talked to him today promoting this show, and there's other people that are actually talking about your show, this show, on his show. So that's a good sign, and I know you got to go. I got to go. So have a good evening, and I will talk to you tomorrow. Bye.
Thank you, Scott, for your good work. Okay, now we're going to go to Mark in Wisconsin. And sorry I keep cutting you short, Mark. Okay, you are on.
Fine. All right, that's fine. This is about the Jack Legg real estate agent. First thing that's happened of interest, the real estate agent's sign got vandalized and sent a letter to the homeowner saying that they wanted them to pay the bill because the money that they'd spend just paying them would instead be spending on lawyers to fight the bill. Now, I don't think that arises to extortion, but does the extortion charge, while it applies to attorneys who overreach writing aggressive letters, does that apply to other people when they write pseudo-demand letters?
Well, I would think of it in the context of a licensed professional.
All right, great. Then I got a second part here. Because
for those who didn't catch, for those who didn't catch the meaning of that, the real estate agent and the lawyer are both licensed professionals. That's what I was referring to. Okay, good.
Right. All right. The second part is much more fun. And in Wisconsin, 183 is the LLC incorporation statute, and it says you've got to have a registered office and a registered agent. This person's listed a UPS store for the registered office. And, of course, UPS doesn't take process service, so it doesn't really function as a registered office. So what I'm looking at is if I approach the court, do I approach a court with an injunction to have the business declared invalid or a writ of mandamus to order the Wisconsin Department of Financial Institutions to declare the business invalid? Because once the business is declared invalid, the 452.10 application verification fees for being a realtor gets kicked in, notably 452.10.1. An application shall be verified by the applicant. If made by a business entity, it shall be verified by a business representative. And, of course, if there's no business entity, it can't be verified, and the whole thing unravels. So what do I do with injunction or a writ of mandamus to a judge?
Wait a minute. There is a who is the agency to whom the licensee is to report? Or who's the governing agency?
There's the local realtor board, but there's also Wisconsin's licensing. And I emailed Wisconsin.
That's the one I'm going to. File a complaint with the licensing board. Generally, licensing agencies have more power and are more likely to wield that power against licensees than a court is.
Okay. Because I've tried to get the business licensing board, a.k.a. Wisconsin Department of Financial Institutions, to, look, this is a utterly bogus filing, dissolve this business, do something. And I got promoted up to the vice president looking out the window on Tuesday, and his reaction was, no, we're not going to do that.
Then file against him.
Okay.
Official oppression. Or official misconduct. It's probably official misconduct in Wisconsin.
Okay.
Failing to perform a duty he's required to perform.
Okay. Well, then would that go to just the writ of mandamus, going, I asked them to perform this duty, they did not, therefore I, court, order you to order them to do their job?
Yeah, yes. Now you're set up for a mandamus.
Okay.
Once you've went to them, and you need to do a complaint to them in writing.
Oh, not a problem.
So it's not a he said, she said.
Right.
And once you get the failure to perform, then you take the failure to perform to the court and ask the court to order them to perform their duty, and also file a complaint against the official at the same time.
Okay.
And it gives the court some leverage. Say, I got this complaint against you. You either get this done or I'm going to process this complaint. We're going to kick your behind.
Wonderful.
Oh, that is so much fun.
Yes, well, I wanted to make sure I dotted my I's and crossed my T's. All right. Thank you much for taking my call tonight, Randy.
Okay. Thank you, Mark. And your timing is perfect. This is Randy Kelton, Rule of Law Radio. David, I'm sorry I won't be able to get to you today. If you have something that's real critical, send me an email at randy@ruleoflawradio.com, and I will do my best to answer it once we're off the air. Thank you all for listening. We'll be back next week, Thursday and Friday. Hope we don't have any more technical difficulties. We had some last night and had to pull the plug on the show. And we had some this week, but I hope by next week we'll have all that fixed. Thank you all for listening, and good night. Dangerous.